My name is Elizabeth Prelogar. I am the former Solicitor General of the United States. In 2023, Tennessee enacted the prohibition on medical procedures performed on minors related to sexual identity, or SB 1. SB 1 prohibits certain treatments for transgender minors, including puberty blockers and hormones that allow minors to transition to a different sex or that treat gender dysphoria. This law violates the Equal Protection Clause of the 14th Amendment because it discriminates based on sex. For example, it provides that minors who were assigned female at birth cannot receive testosterone to present as male, whereas minors who were assigned male at birth could receive testosterone. The Equal Protection Clause does not permit this unequal treatment based on sex.
My name is Jonathan Skrmetti. I am the Attorney General of Tennessee. SB 1 does not discriminate based on sex. It simply sets age and use-based limits on certain medical procedures.
I'll be the judge of that. The question before us today is whether SB 1 violates the Equal Protection Clause of the 14th Amendment. And our answer is no, SB 1 does not violate the Equal Protection Clause.
We dissent.
What? How did you make that decision?
SB 1 does not discriminate on the basis of sex, nor on the basis of transgender status. Instead, it discriminates on the basis of age because it prohibits certain treatments for minors only. It also discriminates on the basis of medical use because puberty blockers and hormones can still be prescribed to minors to treat certain conditions such as early onset puberty, but not to treat gender dysphoria. SB 1 does not discriminate on the basis of sex because all minors, regardless of their sex, are prohibited from receiving puberty blockers or hormones to treat gender dysphoria. Because the law does not discriminate on the basis of sex, it is subject only to rational basis review, meaning we will uphold it if it is rationally related to a legitimate government interest. SB 1 clearly passes this test, as Tennessee has a legitimate interest in preventing the administration of puberty blockers or hormones to minors for gender dysphoria, because these treatments can cause irreversible sterility, increased risk of illness, and negative psychological consequences, and their long-term effects are unknown. Therefore, we uphold the Tennessee law.
I concur and write separately to note that the United States should not have relied on Bostick versus Clayton County to argue that SB 1 discriminates on the basis of sex, as Bostick involved an analysis of Title VII of the Civil Rights Act of 1964, while this case involves the Equal Protection Clause of the Constitution.
I concur and write separately to address my view that transgender status does not constitute a suspect class. Suspect classes must exhibit characteristics that define them as a discrete group, be historically subject to discrimination in the law, and be a minority or politically powerless. I do not believe transgender people meet all these criteria.
I concur, but I am unconvinced by the majority's conclusion that SB 1 does not classify on the basis of transgender status, and I agree with Justice Barrett that transgender status should not be treated as a suspect class.
I dissent. SB 1 clearly discriminates on the basis of sex and transgender status, making it subject to intermediate scrutiny. The law only bans hormones and puberty blockers when they treat gender dysphoria or enable minors to transition sexes. Medical providers can prescribe these medications to treat any physical or chemical abnormality present in a minor that is inconsistent with the normal development of a human being of the minor's sex. This means that physicians in Tennessee can prescribe testosterone to help a male child, but not a female child, look more like a boy, or can prescribe estrogen or a testosterone suppressor to help a female child, but not a male child, look more like a girl. This is clearly a classification based on sex.
I agree that the proper standard is intermediate scrutiny, but I take no position on whether SB 1 would survive that scrutiny.
No, the proper standard is rational basis because SB 1 does not discriminate based on sex or transgender status. We uphold SB 1 under rational basis scrutiny because it is rationally related to a legitimate government interest in protecting the well-being of minors.
You rule, Supreme Court.
You suck, Supreme Court.